three different separate easements dating back to the 1800s between property owners who owned Lot 1, Lot 2, and Lot 3 of what now is Lot 1 was owned by the plaintiff, and Lot 2 and 3 are owned by my client, who is an attorney in Murfreesboro, and Lots 2 and 3 are her office. At the time this lawsuit was filed, the easement between Lot 1 and Lot 2 had not been used in well over 30 years in any regularity at all. We're here today stemming from an appeal from a motion for summary judgment by way of a motion to alter or amend. The plaintiff filed a lawsuit. There was an original answer filed, and that original answer included defenses pertaining to regarding standing and whether in fact plaintiff owned the building or not, and breaks in chain of title and those kind of issues. As a result of that, they filed a motion for summary judgment to address those issues. Prior to the motion for summary judgment being heard, there was a request to amend the answer and to file a counterclaim. The trial court granted that motion, and the amended answer was filed, which raised wholly different arguments than were raised by the original answer, including this claim for the counterclaim was a declaratory judgment asking what rights plaintiff would have over this shared staircase. I said it's Lots 2 and Lots 3. It's actually, there is a staircase. I guess there's a dispute of there is a staircase that goes between Lots 2 and Lots 3, and that's how you get to the top of Lots 2 and Lots 3. We went for the motion for summary judgment. The introductory paragraph in the memorandum of opinion issued by the trial court states, defendant's claim for plaintiff is not the true owners or the alternative easement was abandoned is without merit and not argued. Throughout the 12-page opinion issued by the trial court, there is no reference to the amended answer that was filed or any of the issues that were raised in the amended answer. The first issue we raised on appeal is whether the record before the court was sufficient to grant motion for summary judgment based on the pleadings and disputed facts. Appellant's statement of additional facts included a fact contained there was a dispute regarding the ownership of Lot 1, or whenever I'll go back to, there's three deeds. The first one being from 1880, the next one being, as you'll read in the briefs, the 1900 Partee deed, and then Miss Knight's deed, who was the owner of Lots 2 and 3, which was my client's predecessor in title. Specifically, one of the facts that we put into as an additional fact alleged that at the time the easement in 1900 was created, the owner of that property had no interest in Lots 2 and Lots 3. That fact was admitted by the plaintiff at that level. When we got our ruling back from the memorandum of opinion, I filed a motion to alter or amend and said there's no basis that you could have made this ruling in light of the fact that there was no ownership of Lots 2 at that time, because the original memorandum of opinion said, I find there's an easement pertinent over lots between Lots 1, Lots 2, and Lots 3 with no rationale based on things like after acquired doctrine, but not addressing any of those issues. Realizing the significance of that finding, the plaintiff decided they were going to withdraw this admission. And so at the motion for alter or amend, in their response to my motion said, we were wrong, this should not have been admitted. He actually did own part of this property. So we are left arguing at the motion to alter or amend a fact that the court clearly hadn't considered, but something that was seminal to that should have been considered would have been against the ruling. As an officer of the court, I did not have a basis to go to the motion to alter or amend and say that's incorrect, 'cause I think the fact was incorrect as it was stated. However, the changing that fact precluded me from being able at that point to go back and argue the additional facts that would have also raised an issue of fact for a trial court. Remember, we're at the motion for summary judgment level. Therefore, we only have to raise an issue of fact to be able to create a sufficient issue. At the motion for summary judgment, when we started discussing this, the court went on to say, while hearing these arguments, that I'm more confused now than I was before. And then after kind of listening to the arguments and the things that were never briefed, never addressed, came back and said, I guess I'm granting the motion to alter or amend to the extent I just stated. The court acknowledged there were some facts that were incorrect. There were other facts that she had found that were incorrect that she also addressed, and told the plaintiff to prepare an order. I think under Owing versus Owing, it's very clear that the Supreme Court has said that it's not appropriate for a trial court to ask anyone to prepare an order, to invite anyone to prepare an order until such time as it has made its findings of fact and conclusions very concisely made to lead someone to that. That is not what happened in this case. As a result, the plaintiff, the appellee, filed a statement of facts in their order from the amended order and added a plethora of facts that were never addressed by the court, never addressed by them in any argument, had never been heard before, and how appellee addresses that in its response brief says, well, the court's able to look at whatever it wants. And I would have no issue with that whatsoever if the court had made reference to it. But if we're at a motion for summary judgment and the court has given a 12-page memorandum opinion which makes no reference to any of those facts, the court ultimately, based on the order that the court signed, made some finding that there was a property line, and as a result of that, the easement that was created in 1900 really was only over half of the staircase, things that were never addressed or talked about before. And I think based on Owings, it's not appropriate that plaintiff was able to basically go back and cherry pick facts to make their case for the judge who clearly didn't articulate it, didn't contemplate it. And there's nothing in the opinion that explains how the memorandum opinion was still right, but on a completely separate, different facts that were in dispute. And based on that, we think that's inappropriate and that was error. Furthermore, based on the finding that the court did find that there was some easement over half of a staircase, this staircase had been in existence since the 1800s.
Did you raise the issue of the court signing that order with the court?
I did, Your Honor. What I did was I filed, how we did it was we filed an alternate order. So they filed their order and I filed an objection stating you've included all these additional facts that were not included, and she decided, the court ultimately went ahead and signed their order anyways. That was part of a late part of the record because the way that the trial court did it was that didn't get included. My objection was included, but my order, which actually followed exactly what the court had held in that transcript, wasn't part of the record until we had to go back, and that's part of what delayed the record getting sent to the court, was we had to go back and say, wait a minute, we need to include the order that we filed to show what it was that got filed so you could see. So yes, Your Honor, we absolutely did address that.
Mr. Buck, I think the issue really is in your stated issues on appeal. Did you raise that as an issue, that this was not the independent judgment of the trial court?
Yes, Your Honor, I did.
For that reason?
Yes, Your Honor, I think on page, I specifically held on page 19, repeatedly, and then I also cite to Owings saying that.
Now, in your stated issues, is that included in your stated issues?
It is included in my whether the court erred in granting a motion for summary judgment based on pleadings and disputed facts before the court.
So, you didn't raise as an issue whether or not this was an independent decision of the trial court. You didn't raise that as an issue.
No, Your Honor. I guess I articulated it as being erring based on the pleadings and disputed facts. I did not state one on that it not being an independent ruling by the court.
What do you say of the disputed facts?
Well, I think that on the record, I think the disputed fact was the owner of Lot 1 had no interest in Lot 2 at the time he tried to create an easement. That's what the record reflects.
And in order to determine that, wouldn't you look at the deed that was executed at the time? Look at the deed and the trial court would have to interpret what was passed as a result of that deed.
You might, but for the fact that the plaintiff had agreed with that issue. So the court never looked at it, never addressed it, never said a word about it whatsoever, because the plaintiff had agreed that that owner of Lot 1 had no interest in that lot. So no, I don't think the court did and never addressed that in its memorandum opinion or in its ruling whenever it ruled on granting the motion to alter or amend.
In your client's, the deed conveying lot 2 and 3 to your client,
Yes, Your Honor.
was there an easement?
Very interesting. That's my next point, Your Honor. On the argument number 3 is the deed of my client and the deed from Mrs. Knight, which was the 1984 deed. The deed specifically states that the property includes and references an easement. Under TCA 66-5101, unless you're going to restrict what you're giving, you are supposed to have some words that put someone on notice about what you're not getting. I can't find any case in Tennessee jurisprudence that references included in as something that would make someone think it is subject to, which is how most easements are noticed. You would specifically say, I'm giving you this property subject to, or I reserve from this, but that's not what her deed says. Her deed specifically says included. And it said it included from 1984 until this lawsuit was filed, in which my client bought her partner out, and lawyers for the plaintiff actually prepared the deed, because that was the title company that did the closing, and all of a sudden the language changes from included in to subject to. So no, there was nothing in her deed that would lead any reasonable person. The court came back and said, it's inartfully created, but we do find any reference to an easement puts someone on notice that you should have looked. However, her deed very clearly says the property description and says included in this is this easement up the staircase into lot 1.
So from reading that description in the deed, it would not have put Ms. Knott on notice that there is perhaps an easement for ingress and egress through that stairway and then through the hallway to lot 1?
I think under the statute TCA 66-5101 that there needs to be specific, clear words that suggest you are getting less than all of the fee, and I think included in would suggest that you are getting more than you are getting something additional to, not less than.
Okay.
Thank you. You'll have your rebuttal time.
Thank you.
Good morning, Your Honors.
Good morning.
I'd like to address briefly the initial
State
issue.
your name.
Oh, sorry. My name is Garrett Anglin of the Rutherford County Bar. I present the appellee. Thank you for having me. The first issue that was raised by appellant is the issue of whether the trial court improperly relied on facts in the record that were not included in a statement of undisputed facts. Now, the main point that I want to address here is that that he relies on the Tennessee Rules of Civil Procedure, Rule 56. Rule 56, the Tennessee Rules of Civil Procedure, do not limit the court in how it may rule on summary judgment. It states that a statement of material facts shall accompany a motion for summary judgment in order to assist the court in ascertaining whether there are any material facts in dispute. And as we cited in our brief, this Court of Appeals has made clear in Butler v. Diversified Energy that a statement of material facts is for the benefit of the trial court and may be waived. And a more pertinent point, too, is that we're not talking about facts that weren't in the record. We're talking about deeds that were, and as Your Honor asked, we're talking about deeds that were submitted into the record as part of the summary judgment and the response to the summary judgment. All of these deeds were referenced consistently throughout these proceedings in order to make a determination as to what they said and what their proper interpretation was. In fact, when we submitted our chain of title, actually verified those deeds through the affidavit of an attorney in Murfreesboro by the name of Thomas J. Haynes. Now, there are two statements of fact that appellant raises that were claimed to be disputed that precluded summary judgment. And those two facts were that the deed from Clark Barton to the parties referenced a right-of-way that was greater than what his father, William Barton, had retained in 1882. And the second fact was that at the time Clark Barton conveyed Lot 1, 102 North Church Street, to the parties, Clark Barton did not have any interest in Lots 2 and 3 other than the interest that was retained by William Barton. Now, the one primary issue with both of these facts is, again, that they are not disputed facts, as in facts that need further evidence or further testimony. They are interpretations of a deed. They are characterizations of deeds. So they couldn't preclude summary judgment because they are questions of law that are particularly within the province of the trial court to determine. So no matter what the characterization of either attorney made of these deeds when they submitted their motions for summary judgment or their responses to the summary judgment motion, when those deeds were submitted into the record, ultimately it was within the province of the trial court to interpret those deeds and to come to the correct conclusion as to how they should be interpreted and what they mean and what their legal effect is. And that's what we're doing here today. That's what the trial court did at summary judgment. That's what the trial court did when it made corrections to its conclusions of law and findings of fact in interpreting those deeds on the motion to alter or amend. Furthermore, not only did the trial court acknowledge these issues being raised by the appellant at the motion to alter or amend and corrected those issues through its conclusions of law and findings of fact in its order, but these issues were corrected by the parties themselves on the record at the hearing on the motion to alter or amend. Even appellant's counsel himself stated on the record before the trial court, yes, this was an initial fact that was stated that Clark Barton did not have any interest in Lot 2 at the time that Lot 1 was conveyed, but that was incorrect. Appellant's counsel stated that we're looking at handwritten deeds from the 1890s and there was an error on my part. I think counsel, he says in response, is withdrawing his acknowledgement, and that was in fact the ownership of how that property was. And even later on, appellant's counsel noted that there's no dispute that Clark Barton did own 1 and 2, being Lot 1 and Lot 2, so he had a right to put an easement across 2. These were acknowledgments by appellant's counsel at the hearing. After a motion to alter or amend had been filed, the issue had been raised, we filed a response, we arrive at the hearing, and both parties acknowledged before the court, hey, this fact is incorrect, this is in fact how it is. And the trial court relied on that in making its determination and then entering an order. Now, appellant's counsel has come before the appellate court and essentially asked that it go back in time and say, well, I don't want to acknowledge that we've all agreed, the trial court and the appellant and the appellee, that these facts are correct. We want to go back and reinstitute this initial admission that everybody agreed was actually an error. Now, the other point that was raised is the 1985 deed. And there were other issues that were raised in the brief, but they haven't been addressed in this oral argument, and if there are questions about them, I'll be happy to address them. But the other issue that we've talked about here is whether or not the 1985 deed to Mrs. Knight actually created a valid express easement. And
is that the easement that you rely on for your client having the benefit of that right-of-way?
we rely on the 1985 deed as well as a deed from 1900 from Clark Barton to Partee, both of which are referenced in this description. And the description states specifically, included in the above-mentioned property, I know you've read this, but I'll recite it for the court, that included in the above-mentioned property is the right of ingress and egress up the staircase and across the hall to the building located at 102 North Church Street, as shown in Deed Book 40, page 589 of the Registrar's Office for Rutherford County. Now you'll note, as we stated in our briefs, in both parties' briefs, that deed from Deed Book 40, page 589, is that Partee deed from 1900 that specifically stated, I hereby convey to Partee a right-of-way through and over the hall and stairway leading to it from the public square, and the same is to be a permanent right under any and all circumstances. The language in that is quite clear. That
was the person who granted that deed an owner of both Lot 2 and 3?
They were not. In 1985, they were. Lot 2 and 3 by 1985 had been conveyed as one parcel since, I believe, 1931.
Let's go back to the 1800s. Was that person the owner of Lot 2 and 3? Because when the right-of-way was created, the dominant estate was Lot 1. The other two lots that were subject to the easement was 2 and 3.
Correct.
In order to grant the easement, in favor of lot 1, wouldn't you have to be the owner of lot 2 and 3?
You would not. And in 1900, in fact, by the time these deeds were done, in 1900, lot 2 and 3 had been conveyed separately. And to clarify that, so in 1882, B.L. Ridley and William Barton partitioned the properties. And initially, the property was lot 2 and 3 with B.L. Ridley, and William Barton had lot 1. And William Barton wanted to retain a right-of-way up that staircase because his lot 1, initially on the partition, was separated from the staircase. So the logic of why he needed access up this staircase is apparent, right? And then in 1884, 2 years later, lot 2 was conveyed back to William Barton. And in that deed, the description of lot 2 specifically stated that there was a boundary line down the center of the stairwell. And thereafter, until, of course, later on when the properties were conveyed as one, there was a dividing line down that center stairwell. So this is from 1884 up until 1900 when Clark Barton conveys, and he receives this through an inheritance. He receives lot 1 and lot 2. And he conveys lot 1 to the parties, and he reserves an easement up that stairwell through the hallway of lot 2 to access lot 1. Now, he wouldn't have had to have encumbered lot 3 because there was a dividing line down the middle of that stairwell, which would have allowed him to encumber a portion of that stairwell without affecting lot 3 at all. Now, if we fast forward,
There was no physical structure dividing the stairway, was there?
there was no physical structure. There was only a legal description that denoted that the boundary line would go down the middle of the stairwell.
And that stairwell is how wide?
It's a double-wide stairwell,
Which means what? How wide?
which essentially means it's I would say it's about 2 doorways wide. So you have 2 gates that actually open out into the street, and if you can open up 2 gates. So you could actually open up one side of the gate and go up the stairwell, and there's a doorway that accesses just lot 2 to go down the hallway to lot 1, right? And so I haven't done an architectural perspective of the building, but I can tell you that there is an easily feasible means of making sure that you could have an easement in 1900 where somebody could only access lot 2 and go up the stairwell and go through lot 2 to lot 1 without actually affecting lot 3. But you fast forward to 1985, and by this time, not only are lot 2 and lot 3 being conveyed as one parcel, they're being conveyed as one legal description. They had been December 16, 1985, on the same day that Martha Knott actually received her interest in the property, whereby this easement was initially created, a survey was completed, and that survey was a meets and bounds description that outlined the entirety of lot 2 and 3. And it was conveyed to Martha Ann Knight. On that same day, Martha Ann Knight executed a quitclaim deed, giving an interest in that property to her husband. And thereafter, and again, Henry's Florist, Mr. Phillips, who's the owner of Henry's Florist, had received his interest in lot 1 in 1984. As soon as the Knights received their interest, you have the easement that denotes that it's affecting this legal description, which is both lots 2 and 3, one meets and bounds description. And then thereafter, you also have to acknowledge the undisputed facts that the Knights actually gave Mr. Phillips a key to that gate that opens out onto the street, onto the public square, allowing him access up this stairwell. Then Mr. Phillips asked the Knights to install a lock on this top doorway so that no one else could access this hallway that goes to lot 1, and that they ensured that he would have access to this stairwell and to this hallway to make sure he could access this upstairs. And in fact, he did so for many years. And there's actually not even dispute. One thing that keeps getting not acknowledged at the appellate level, which was acknowledged at the trial level, is that there really isn't a dispute that Mr. Phillips has had an easement for years and that he's used that easement for years, right? But yet at the same time, we're sort of trying to ignore that and focus on these technicalities, which really aren't persuasive at all. If you actually read the deeds and their reasonable interpretations, clearly indicates that an easement was being created. Now, if you combine those with the facts of what the Knights did to allow Mr. Phillips to use that easement, there is simply no dispute that there was an effective easement that was in place at the time.
Typically, the language used to create an easement, would it be similar to the language that appears in this deed in 1985?
In 1985, and again, the dispute has been over the language of included in. But once again, you also have the language of right of ingress and egress, right? And when you look at language that says right of ingress and egress, that is effectively a term of art, especially when you are using such language in a deed that's almost used exclusively to denote an easement, especially a right-of-way. An ingress-egress easement is one of the most common that's granted, and usually that language is only specifically used when an easement is being granted. So,
Would you normally use the language included in, or would you say
subject to? You would normally say subject to. But that doesn't preclude the reasonable interpretation that a party's been placed on notice that a right of ingress and egress has been included with a deed, and that puts that party on notice, especially the party who initially received the deed, acknowledged the easement, was aware that it existed, and effectuated its use. And that's the appellant's predecessor in title. So we don't have parties who didn't know that the easement existed or felt surprised by finding it out. They actually acknowledged that it was there. Now the other fact is when you talk about this in 1885 deed, you have to look at what the reasonable interpretation would be. And appellant contends that the only reasonable interpretation of Mrs. Knight's deed is that the owner of lots 2 and 3 conveyed a right of ingress-egress to themselves up their own staircase across their own hall to access the separately owned building that they were given no permission to access. And appellant is essentially arguing this must be the only interpretation, that's not valid, so we don't have an easement here. That is not a reasonable interpretation. It is very clear in Mrs. Knight's deed that a right of ingress and egress was being created. Then the Knights turned around and effectuated that right of ingress and egress to Lot 1.
Let me ask you, in the court's memorandum opinion, I guess in 2022,
Yes, Your Honor.
she makes reference to this motion to dismiss the counter complaint under Rule 12. This is not a motion to dismiss under Rule 12, is it? That would implicate attorney fees, because basically what happens, I mean, you filed the action for declaratory judgment, they filed a counter for declaratory judgment about whether or not an easement is created, and the judge accepts your view that an easement was created, and in effect rules against the counter complainant, but not a dismissal of failure to state a claim.
Yes, Your Honor. And the reason why that the motion to dismiss was filed and why it's a separate ruling as opposed to the summary judgment is because the summary judgment did rule on the declaratory rights of the parties with regard to the easement. It ruled that there was an easement that affected both lots 2 and 3 for the benefit of Lot 1. Simple as that. The motion to Yeah,
but that ruling doesn't have anything to do with the sufficiency of the counter complaint.
Yes, Your Honor.
It's just a determination that based on my review of these deeds, that it created an easement, as opposed to the counter complainant arguing that it didn't create an easement.
Yes, Your Honor. And the point of the motion to dismiss was not to address those, which we did. When we filed the motion to dismiss, we said the summary judgment disposes of these declaratory rights. Our motion to dismiss was focused on the rightness of an issue, because in the counter complaint, one of the main additions that was made in the counter complaint was the appellant alleged that there was going to be an anticipated overburdening of the easement based on a belief that they had garnered from a deposition of Mr. Phillips saying that he was thinking about maybe trying to rent out his upstairs. And so they filed this counter complaint claiming, well, we think there might be an overburdening at some point in the future, so we want to go ahead and file this with the court and address it. And we filed a motion to dismiss, and we said, Your Honor, this issue is not ripe yet. It has not become an issue. There is no overburdening. None of the actions that appellant is anticipating have occurred yet, so we don't have a justiciable controversy. And that was what the motion to dismiss was focusing on when it was being granted.
But the other part of the claim, the counter complaint, was whether or not there is an easement. And that was right for the court to make a determination about, is there an easement?
That's correct. That's correct. And when we filed the motion to dismiss, we alleged that if the summary judgment dealt with this issue, then it would have dealt with the issue both from the complaint's perspective and the counter complaint's perspective, and that issue would be rendered moot. So the only issue that really could be dismissed per se would be the issue on the basis of rightness. So the summary judgment actually is dealing with the declaratory rights in both the complaint and counter-complaint in combination.
And so I'm still trying to figure out why that would implicate a grant of attorney fees under the statute, since this is a determination on a motion for summary judgment and has to do with the court making a decision in connection with the declaratory judgment raised by both parties.
Yes, Your Honor. Well, I would submit that I don't believe that we have requested attorney's fees, and I don't believe that that's an issue that we were trying to deal with at the trial level. So the only issue was ensuring, I believe that the only focus that we had was ensuring that an unripe issue would not remain before the court if every other issue had already been decided. So we haven't sought any sort of benefit of the motion to dismiss other than just to seek the dismissal of an unripe claim.
So you're acknowledging then that the decision in this case doesn't implicate the statute that would grant attorney fees?
It does, but we haven't requested those fees, I don't believe.
Well, I'm not sure what your position is.
Well,
I'm trying to figure out, do you think that a trial court ruling on a motion for declaratory judgment brought by both sides and making a decision in favor of one side and against the other, would that implicate Rule 12 and a grant of attorney fees for the party that lost?
In this situation where one of the claims, the claim that was not right, the anticipated overburdening, was in fact dismissed by the trial court, would implicate Rule 12 and would implicate the statute that would involve attorney's fees.
Okay.
Admittedly, we haven't requested them once again, but it would implicate that rule and that statute.
Okay.
Thank you, Your Honors.
Thank you. You have 3 minutes, Mr. Pope.
Thank you, Your Honor. Your Honor, I think you're exactly correct. If you go back and read the memorandum opinion, they in fact did ask for attorney's fees. The judge said, I'm going to withhold that issue until this becomes final. Then we'll come back and talk about attorney's fees. So to say that that wasn't ever addressed is inconsistent with the court's ruling.
Let's assume you lose on appeal. In your view, would they be entitled to attorney fees under that statute?
I don't think so, Your Honor. 'Cause I think the dismissal is inappropriate based on a couple grounds. Number one, because originally the court had originally the court dismissed the counterclaim finding that there was an easement across both lots 2 and 3. However, in the amended memorandum opinion, as you just heard counsel talk about, the partee deed said there's only an easement across lot 2, not across lot 3. Regardless of whether you own lots 1 or whether my client owns lot 2 and lots 3, by definition, there's a division between lot 2 and lot 3. The fact that Ms. Knight's deed references an easement, if the court finds it referenced an easement, then it would only be on what was created under that 1900 deed, which would be across lot 2.
Well, in 1984, 85,
Yes?
when that deed was given, the owner owned both lots 2 and 3. So if they wanted to subject both to an easement, they could do that.
I would agree. And if they had said that we're going to give an easement across both lots, I would agree. But if you reference back the deed from 1900, then I think you have to look at what was the interpretation of what was created in 1900. An easement, allegedly an easement across lot 2. So me simply saying, I'm going to give you that easement doesn't all of a sudden spring and create forth a new easement across lot 3 as well. That's interpretation. I think you have to look back at what was granted. If the court found, which it did, that the 1900 partee deed created an easement across lot 2 only, which was also contrary to its memorandum opinion, then when Ms. Knight references that exact easement, I don't see how it springs forward to 3 because she owns both. I can give you an easement to half of my property. I'll give you an easement to my entire property because I own it all. So I don't think that's the same thing. And the counsel, if you go back and look at what the transcript says, this is a joint hall, regardless of how it's owned, it is a double-wide staircase that goes to a double-wide hall with no dividing lines between lot 2 and lot 3. And these are all wonderful facts and conclusions that, as I addressed earlier, are nowhere found in anything in what the court decided. The court literally comes back and says, I'm confused, I guess I'm gonna grant this motion, and then says, prepare the order, and all of a sudden, things that were never in, the court's correct, could have been interpreted, could have been found, were all of a sudden put into an order that she signed over the objection of counsel.
You do agree that in the final order entered in 2023, the court said alternatively, the deed in 1985 created an easement? And
Yes.
there was no reference to what happened in the 1800s.
It was inartfully created, yes, Your Honor, and part of our basis for our appeal that we articulated was, if it was created, it could have been created what was cited to in the 85 deed, which was an easement over Lot B, or Lot 2, not over 2 and 3. Just referencing back to the easement that was actually from 1900, which you asked, did the owner of Lot 1 and Lot 2, guy who owned Lot 1 had ownership of Lot 2, he could put an easement on Lot 2. Doesn't mean he had a right to put it against 3, whether 3 is owned by whomever. I can buy Lot 2 and Lot 3 and say, you only have a right to use that. You don't have a right to my entire property because I own 2 pieces of property. Otherwise, every easement would mean if I own the property, you can go wherever you want because it's my property and I gave you an easement. You have to look to what the terms of that easement are. Based on that, we think this opinion should be overturned and remanded back to the trial court.
Given that this easement is in a double-wide stairway, then the owner of Lot 1 or any invitees could access the stairway, then go up to the hallway and go across into 1. Is that right? Why would that impair Lot 3 at all?
Well, I think because, quite candidly, I think it's a prescriptive easement between Lot 2 and Lot 3 that goes back over 120 years. And whenever you give somebody, I don't think you have the right to give somebody access to something that you don't have exclusive access to. So I don't think the owner, if these 2 buildings were separated, I don't think you have exclusive access to Lot 2, which is what we'd argued in our brief. But once again, that was never argued before the trial court because it was undisputed that the owner of Lot 1 had no interest to be able to convey, which the court had no issue with and didn't interpret that deed any other way until, in fact, it came back on the motion to alter or amend.
Thank you.
Thank you, Your Honor.
Thank you, gentlemen. We'll take the matter under advisement, render an opinion as soon as possible. Please call the next case.
Teoflia H. Mockney